Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. We often talk about alimony or spousal support in relation to discussing divorces because that's something that comes up. Certainly in marriages that are of a duration of at least 4, 5, 6, 10 years, those kind of marriages, it's at least in play. It's at least part of the discussion. Whether there will actually be alimony, a different story, but it's certainly part of the discussion when you talk about a divorce. Now, can alimony be terminated under any circumstances? Alimony can be terminated under certain circumstances, but to the statement, alimony can be terminated under any circumstance, I would say that's an untrue statement because it's inaccurate. There are certain circumstances when alimony can be terminated. It'll have to be circumstances that the court takes into account and determines that it makes sense to terminate it. So, for example, many years ago, your judgment of divorce, when there was an alimony provision, it said something like the alimony will continue until death or remarriage of the recipient. So those were the circumstances outlined in a lot of judgments. So if somebody was getting alimony and they remarried, they knew full well once they remarried, the alimony is getting cut off. So that's how it would change. Nowadays, most of your judgment says that the alimony is going to continue until further order of the court based on a change in circumstances. So the court could order that alimony should change. But remember, your judgment is like a contract. The contract says, I'm getting this, you're paying this. It deals with the entitlements. It deals with duties. So if a person has a duty to pay alimony, the contract's going to bind them to do that. And the only thing that's going to relieve them of that is if the court finds that there's a change of circumstances which justifies a modification. I wouldn't say any circumstance will do it. I would say it's only a compelling circumstance. So for example, if a guy's paying alimony and it's based on the fact that he used to make $50,000 a year, and now, because of union concessions or whatever, instead of getting $20 an hour, he's now going to get $19.85 an hour. So he won't quite make the same amount. He's going to make a little bit less. I don't know that the court would necessarily modify the alimony on that because the court may deem that, yes, it's a change, but it's not significant enough to revisit the issue. The court doesn't want to have to constantly engage in the accounting every time someone makes a few dollars more, a few dollars less. That said, if the court gave alimony based on someone making $50,000 and now they've lost all their overtime and now they're only making $20,000, you can well bet that the court is going to issue an order changing the alimony, running the numbers again based on the new salary. Why? Because not only is it a change, but it's a significant change in circumstances. It's enough of a change so that the court could say, you know what, had I known that at the time, I might not have ordered any alimony or I would have ordered considerably less. So yes, alimony can change. Can it change under any circumstance? No. There are certain limited circumstances that are available that the court can utilize. It's going to be in the court's discretion to determine whether or not what's going on right now supports the modification or the change. If you have any questions about that, reach out and we'll be glad to help you out.